Lord, I had quoted this previously. It's the decision of State versus Agliotti, my Lord. It's a reported decision at 2011, Volume 2 of the South African Criminal Law Reports, page 437, a decision of the Gauteng South Johannesburg High Court delivered by a former judge as a trial, my Lord. And I want to read it to your Lordship, if I may. Paragraph 286 to 288 is where he touched on this, and this was at the stage, my Lord, of Section 174 discharge with the judgment on that. And at 286, his Lordship says, the timing of the supplementary affidavit by NASIF and its contents which belatedly tend to implicate the accused herein points to a predetermined or premeditated course of action to implicate the accused in the crime set out in the indictment. I cannot see any reason why, if the contents of this affidavit were true, it would not have been part of the Section 204 statement that NASIF deposed on 8 November 2006, or the statement he made on 10 November 2005. They sound to me to be recent fabrications in the defence's charge that they were specially elicited or put to NASIF by the investigators or the prosecutors at the time, for him only to glorify saying that his signature may have a ring of some truth to it. So in that instance, my Lord, there was a 204 witness that was asked to elaborate on his statement so as to implicate the accused further. Then at 287, and this is the crux of it, my Lord, his Lordship's held as follows. Any attempt to manipulate the evidence of a state witness so as to ensure that he or she testifies in court about matters that are not covered by his or her statement or of which he has no independent knowledge, and more so where the statement is in terms of Section 204 of the Criminal Procedure Act, is irregular and may be unconstitutional and render the trial unfair. 288. The defense court statements made by the Section 204 witnesses as well as statements by other key witnesses to be handed in at this trial, in order to illustrate that they testify about aspects that have not been covered in the Section 204 statements. This tends, in my view, to show some semblance of interference with those witnesses before they testified, under oath in this court. It points at, or to, irregular action on the part of either the investigating or prosecuting team to cajole witnesses into implicating this accused, where such witnesses did not spontaneously implicate him. And that's directly relevant here, my Lord. There's then reference to the Razani decision, my Lord, in that judgment. The other authority for this, my Lord, is State versus M. It's a decision of the Supreme Court of Appeal, my Lord, which is cited at 2002, Volume 2. I repeat, 2002, Volume 2 of the South African Criminal Law Reports, page 411. The decision that was delivered by the Mr. Justice Hare. At paragraph 30, my Lord. It's a long paragraph, and to read it. Turning to the third irregularity, no foundation was laid by counsel in support of his objection to the admission of the letter received by Ngema from the accused, albeit that the magistrate ruled somewhat summarily that the letter was obtained in the course of an investigation into the offence of a statutory rape, was therefore admissible. His ruling was interlocutory and always open to challenge by the defence after laying a proper basis. But as I have pointed out before, defence counsel did not seek to lead the witness in re-examination on the circumstances which the state obtained possession of the letter and the ruling stood. The magistrate did not refer to the matter in his judgment. He did, with justification, use the letter to establish the origin of Ngema's witness statement. This was instrumental in fragmenting the witness's credibility, and if the letter was improperly admitted, must have had a substantial negative impact on the fairness of the trial. The court, I quote, gave no separate attention to the admissibility of the letter. It seems to have assumed that it was tainted by the improper interrogation. Then a review of the authorities. It says, after review of the authorities, the court concluded that it had the discretion to exclude evidence improperly obtained. There's several references. It says, there is no doubt that such a discretion exists based at common law upon a proper balancing of the competing interests are clearly identified in State v. Hammer Supra and under the Constitution. I beg your pardon, my Lord, the more appropriate place, my Lord, is before that, at paragraphs 28 and 29. But if I may go back to that, my Lord, it's on page 430 of the judgment. It says, it will be convenient to deal with the first two grounds of irregularity together. The overall conduct of the investigating officer towards the witness in Gemma represented a gross and reprehensible departure from the standards of fairness which the common law recognizes and the Constitution of the Republic of South Africa guarantees to an accused person. The conduct of the policeman leaves little doubt that the arrest of the witness, lawful though it may have been, was a stratagem in the process of intimidating him with the object of procuring at least a retraction of his statement. The freedom of witnesses from interference, whatever the side they may take, is a keystone in the temple of justice. Without it, the structure would disintegrate. The police, above all, should preserve its integrity, as their own function would become frustrated by its violation. No authority is needed for this instance. Indeed, there seems to be no case directly in point in this country, but some guidance may be obtained from Rex v. Manda, 1951, 3SA 158A. Much weaker case on the fact that in the present Shana J. said at 166A to 167C. At the preparatory examination, the appellant was asked if he wished to have any witnesses subpoenaed under the provisions of section 244.2 of Act 31 of 1970. They gave the names of 3 witnesses, and in the case of 2 of these, the police then took statements from them which were available to the Crown for cross-examination. This should not have been done. It is, of course, in general the duty of the police to collect all the available evidence that may throw light on the commission of an offence. The court would certainly not wish to raise obstacles to the due fulfilment of that duty. The statement should not be taken from persons whose ability to give relevant evidence is only discovered as a result of an application by an accused person for the assistance provided by section 244.2. That section is an important aid in the proper administration of justice, and accused persons should not be deterred from resorting to it at the stage of the preparatory examination through fear that their witnesses will go into the box handicapped by their having given statements to the police which may not necessarily contain full and accurate accounts of the evidence that they are prepared to give. There's also a reference to Moromisi versus Motorvoertuig Assuransie Fonds, 1983, volume 4, SA 2070, and State versus Mancola and others, 1987, 1 SA 507C. Paragraph 29. The behavior of Captain Zwane in this case appears to have been so at odds with his duty that one must express the hope that the authorities will embark on an appropriate inquiry if they have not already done so. The degree of undermining of the witness which occurred, if one were to assume that the evidence was material to the fate of the prosecution, I'll just repeat that one. The degree of undermining of the witness which occurred, if one were to assume that his evidence was material to the fate of the prosecution, was such as would, in the absence of very strong countervailing features, substantially nullify the accused's right to a fair trial by the severe violation of his right to adduce and challenge evidence. In the light of this very obvious irregularity, the magistrate was surprisingly muted. However, the magistrate did not again refer to the statement or the contradictions between it and the statement in the remitted application. His finding that Ngema was a deliberate liar set up to pull a red herring across the record derives from problems with his evidence unrelated to Captain Zwane's machinations, save in relation to the letter which the witness received from the accused and to which I refer below. This was also the approach adopted by the court, I quote. The 2 previous courts were justified in the approach which they adopted. So my point, my lord, is that Ms. Chiloto was identified even by the state as having given an exculpatory statement relating to what was the premier at the time, Mr. Makashule, at the Zondo Commission. She then immigrated, she was then taken by surprise and really ambushed and coerced to give a different version, which she refused to do, which is the reason why this court ought not to have jurisdiction over her, and is a further reason why accused number 13 will not receive a fair trial. They are joined together with respect, my lord. I may just take a look at my notes, my lord.
Yes.
Yes, my lord. In essence, Ms. Chiloto's reason as to why this court doesn't have jurisdiction relates to the fact that she claims to have been tortured and intimidated. And we say the only reason why she was tortured and intimidated was to implicate our client. And that's why we have a direct and substantial interest in this matter, my lord. And that's why we say it goes to the jurisdiction. And we have a, but for the fact that she was the PA to Mr. Makashula, she would not have been charged and she would not have been approached and treated in the manner in which she was. So we said that's the reason why we ought to be entitled to cross-examine on those aspects, my lord, which
Yes,
relate to this very inquiry.
What is a concern to me, Mr. Houders, is that if there was an attempt to coerce her to say certain things against your client, then it appears to me, having a look at the Exhibit 11, that is RA1, that it didn't materialize. She did not implicate him.
Yes, my lord, the fact that a person attempts to do something that doesn't succeed still makes them guilty of having tried to do so, and it impacts on the fairness of the trial. So if we take, and this will be I can give you, your lordship, the structure of my cross-examination. When accused number 13 was arrested, as a fact, my lord, he was told, not there's a potential, but he was told, Ms. Charlotte is a state witness. You may not communicate with her. At that stage, Ms. Charlotte and Mr. Makashula shared the same attorney. And that's why the emails that were used here, my lord, were from Mr. Nkwashu, my attorney, accused number 13's attorney, and Ms. Charlotte's former attorney, and it relates directly to what happened in that regard. And we say that the fact that you don't succeed in bribing a judge will still taint the proceedings by the virtue of the fact you even attempted to do so. And we believe that that taints these proceedings in their entirety, my lord. And we can show, my lord, even stronger than that. I can give you, lordship, a few examples of issues, even though the witness is here, my lord, as to what I was going to deal with in the cross-examination. And it's aspects, my lord, that make it very clear. I can give one at the top of my head, my lord. Your lordship will remember, and as your lordship said in the warning statement, Ms. Charlotte had given a date by which she would provide a warning statement. It's there. I think it's the 26th, my lord. It's 1 month. It's the 23rd. She had 1 month within which to do so. But, my lord, it's an objective fact that on the 6th of October, there was a warrant already issued for Ms. Charlotte, irrespective of the fact that she'd given that time to provide a warning statement. So now you've heard, and I believe it's significant, my lord, the state saying, oh, but you never even reverted to the warning statement, so we charged her. But that is defeated by the objective facts, my lord. And I need, with respect, to put these facts to the witness and to deal with those issues because they impact on the fairness of the trial of my client. And there are other aspects, my lord. But that's just one clear example, as was, with respect, my lord, RA1 exhibit, I don't know what tab it falls under, the recording of what happened in the meeting emanated from us, my lord, and we believe that we're entitled to put to the captain aspects relating to that interview. Because his version in our submission, and I made it clear when I addressed you, lordship, is not borne out by that transcript in material aspects, and it is in other aspects, my lord. As I said, it's a third version, that's how I explained it at the time. And the contents are there, they speak for themselves. We believe it would sincerely be in the interest of justice for us to be granted the opportunity to cross-examine. Should irrelevant questions be asked, my lord, we accept that there's no obligation to do, but we undertake not to ask irrelevant questions, my lord. It will only pertain to that very aspect.
Thank you, Mr. Houders. Mr. De Nijssen, on the last occasion, you objected in advance to Mr. Houders cross-examining this witness. You heard what he said now. Are you still of the view that he shouldn't be allowed?
Most definitely. There's a huge difference between the cases that he quoted and the case in Castle. In all those cases, the police acted untoward to alter statements or to have statements made. That didn't happen in this case. Q17 didn't make a statement. The police didn't even get to section 204 if it was applicable. There is reference made to this document, and the court has the papers. In the replying affidavit that my another colleague referred to, that we should have had knowledge of, it is stated by accused number 13 that he obtained this transcript, or rather the information from which the transcript was made, on the 28th of November 2021. It's impossible. By that time, the police hadn't even visited America. Then just another aspect. My Lord, with the utmost of respect, if accused number 17, and I've said it throughout this trial, while we were struggling to get her out of America, had she still been in America, for whatever reason, we would have continued with this trial against accused number 13. That's another guarantee that her cooperation or not has no bearing on the prosecution against accused number 13 as we stand today. And again, I say, she didn't give a statement. She made certain averments, but there's no statement that we could use as indicated against accused number 13. There is still no basis, with the utmost of respect. Thank you.
I'm good if I may reply. I would like to correct two misstatements by the nation, and I have no intention of becoming personal on this, but I want to refer your Lordship to the Exhibit 11 that we have before this Honourable Court, my Lord. It's with the old RA1. And your Lordship will see on page 3 of that document, Brigadier Gerber does refer to section 2 of there was reference and it was brought in, and I want to read it to your Lordship because it makes it clear. And it will also, my Lord, clear the other misstatement by Mr. Donation, that she had already at that stage made a statement, my Lord, that they did have in their possession and were fully aware of. So at page 3, my Lord, Brigadier Gerber says, so at this stage, if you do at any stage, how could I say implicate yourself in anything? She says, Brigadier Gerber, we will obviously then, but at this stage there is no reason for us to warn you in terms of any judge's rules or etc. But if you do incriminate yourself, we will stop you and we'll give you the proper warning in terms of that. And then we will discuss the matter forward with you, because there is the three options. We can either, if you do implicate yourself, I do not know if you know what a 204 witness is. Mr. Lotta says, you can explain further, please. Brigadier Gerber, okay, the 204 witness is, if you're involved in anything, you come forth with it, we take the statement in terms of section 204 of the Criminal Procedure Act. She says, He says, which then still allows you to be a witness for the state, bearing in mind that you have to be forthcoming with your part in the process. She says, okay. Then he says, page 4, the court finds your testimony is truthful, they would absolve you from any wrongdoing in the case, but your testimony is important in that aspect, all right. And then he says, my Lord, if we proceed and it becomes apparent that the 204 route will not work, or you're unwilling to go that route with us, obviously we would have to explore other avenues then in terms of maybe viewing you in a different light as a suspect in the matter, which is not at the current stage what we are doing. Ms. Chilotta answers, okay. Brigadier Gerber says, alright, so this interview will depend on how you approach us. Ms. Chilotta says, Brigadier Gerber says, and what we get from you out of the interview. And then it says, okay, she says, okay, so is, he says, okay, so she says, can I ask a question? He says, yes, you can ask, please. She says, is interview part of being a state witness, or is a follow-up based on? And he says, yeah, it is part of it. Is a follow-up on a statement you submitted of the state. She then says, on the Zonda Commission, he says, yes. She says, then he says, but we from our side as SAPS, as DPCR, we need a statement from you, a comprehensive. So she says, as a what? As a state witness, or as a, he says, as a state witness, yes. She says, so I am the state witness. He says, You're a state witness, yes. At this stage, we are viewing you as a state witness. She says, okay, so I've been told now that I am a state witness because ever since I've been seeing everything on media, I've never been approached by anyone. I've never received any letter, any some days where I'm asking now that. He intervenes and says, you're not truthful about that because I sent you an email. We know the date of the email, my lord. You sent, she says, after my email, he says, yes. She said, I said I'm aware of what is happening, so I'm the state witness, it is fine. He intervenes and says, yeah, we did not know where to get hold of you there, but say eventually, and she says, but my contacts have always been there, but it is okay, I understand. So it's clear, my lord, and I can take your lordship through, and I can even take you to this witness's statement before the Constitutional Court, which absolutely carries it home, my lord, if I may refer your lordship to it, which is already an exhibit before this honourable court. But the first point I'm making, my lord, is number one, she was threatened with either being a 204 witness or a suspect. It's clear from the transcript. Over and above that, my lord, it is clear that they were aware of a statement that she had. And then the most crucial aspect of this point, my lord, is in the file that's already before your lordship as Exhibit N. It's the tab, my lord, that deals with the Constitutional Court affidavit that was deposed to by Captain Carlett. Paragraph 133 and 134. He says, the fact that Mr. Rotter did not attribute certain instructions to a former boss had the result that she was then treated as a suspect in relation to some of the same charges Mr. Makashula, a former boss, was facing. So now we have an issue, my lord. There it is, black on white. The fact that she failed to attribute conduct made her into a suspect. Now that goes against, well, we had evidence against her before we began, which was his evidence in chief. But paragraph 134, he says, I deny that Miss Charlotte's liberty was ever threatened. She was merely warned that she was, owing to her non-cooperation, considered to be a suspect. The choice to cooperate or not was Miss Charlotte's to make. There was much evidence to hand that she facilitated payments from alleged service providers in respect of various bursaries and other educational related expenses through the office of the Premier in the Free State. In my view, that evidence was sufficient to treat her as a suspect. So there's that threat, you're a suspect unless you give us the version that you're looking for. And then, my lord, what we have, and it's in the same file, and I'm going to take your lordship to it if I may, we have the exchange of emails, and I had said to your lordship that it was our intention during cross-examination to introduce an email that the state was in possession of that follows on the trail of emails that we have under tab HR, my lord. Then in HR, further on, my lord, we have AA7, which is then a letter on the letterhead of the Premier of the Free State Province to Ms. Charlotta. That is dated 16th of August 2022, my lord, which is headed, or it's addressed to Ms. Charlotta, possible termination of the bursary. It says, this letter is addressed to you in terms of paragraph 3.3 and 4.15 of the bursary agreement concluded between yourself and the Office of the Premier on 4 February 2020. It came to my attention that a warrant for your arrest has been issued in South Africa, and an application for your extradition to South Africa was submitted to the relevant authorities in the United States of America. And then it says that it would appear as if you failed to provide your cooperation with the law enforcement agencies in South Africa. That is in breach of paragraphs 332 and 334 of the bursary agreement. And you'll see, my lord, that she's then invited to make representation by 31 August 2022. And the author of that document, my lord, is Mr. Kopung Ralikotani, the Director General, whom this witness admitted under cross-examination he spoke to frequently but never obtained a statement from. The next document, my lord, is AA8, where Ms. Charlotta then makes representations to this very same person, Mr. Ralikotani, explaining her position that she had intended to cooperate and how important the studies are to her. And then that's followed, that's, if I can put a date to that, my lord. It's not dated, but at AA9, her letter, and he says, my letter dated 18 August 2022, as well as your replies dated 18 and 19 August 2022 of reference. Kindly be advised that I've duly considered your representation and I have decided to keep my decisions regarding your bursary in abeyance pending our meeting. You are directed to report to my office within 10 days of the date of this letter to enable us to resolve the impasse with the South African law enforcement authorities. Should you fail to do so, your bursary will be revoked with must will not be necessary. And I trust that you will find it in order and then signed off by Mr. Ralokotani, 19th of September 2022. And then the final letter, my lord, that then puts us finally to bed and shows exactly what did in fact happen is it's got a heading here, AA10, my lord, from the office of the Premier, from the very same Mr. Kupung Ralokotani, and it's addressed to Ms. Chiloto on the 6th of October 2022, and it's headed termination of your bursary. Previous correspondence exchanged through emails, especially my letter dated 19 September 2022 and your reply of 21 September 2022 of reference. Your submission does not provide substantial motivation for me to review or reconsider my decision to terminate your bursary with immediate effect. No further payments will be made to support your studies. The Office of the Premier, however, remains responsible to pay for your flight ticket to return to South Africa should you wish to do so. So these, my lord, are the clearest indication of the stratagem that was employed to pressurize Ms. Chiloto to, in our submission, falsely implicate Mr. Makashule in the commission of these offences. They played a role in the state having, in advance of ever receiving a statement from her, my lord, labelling her state witness, where the only statement that was in existence at that stage, my lord, wasn't in the docket, it was at the State Capture Commission, and it was totally, it's here before your lordship, I can show it to your lordship, it's totally exculpatory of Mr. Makashule, so it has a direct impact on this inquiry and is influenced by this, my lord. May I just see a note, my lord, before I sit down?
Yes.
My lord, we say that this would be the correct time to allow the cross-examination because it will have a bearing on the very inquiry that your lordship has to answer through a judgment. We see no harm in the evidence being properly fleeced out at this stage, my lord, as opposed to, as I used the example previously, my lord, of coming up with the transcript of the proceedings at a later stage when the court cannot take it into account. And we don't believe it can cause any harm, my lord, in the administration of justice. In fact, we respectfully submit, my lord, that to refuse cross-examination would be detrimental to these accused and would be a failure and would result in an unfair trial. It's regarded, my lord, as one of the most powerful tools in securing the truth, and that's after all is what this court ought to be seeking at this stage, my lord. Thank you, my lord.
Yes. Mr. Houders, the court is not yet fully satisfied that your client has any interest that could bear any fruits at this point in this trial, within a trial, and the verdict of the court, whether the court has the jurisdiction to try accused number 17 or not. I'm not satisfied that that is the position, and I'm going to give you a last chance. I'm being honest with you, Mr. Houders.
I appreciate that.
In order to be fair towards you and your client. Because if I look at it, say for instance, this court decides that the trial must go on against accused number 17. I reject, in other words, the plea of no jurisdiction. How will it impact upon the interests of your client?
No impertinence intended, and I apologize in advance.
Yes.
It raises certain questions, my lord, if I may, and I'm being absolutely honest with the lordship, and I excuse myself in advance. My lord, the refusal to allow cross-examination results in more questions than answers, and I'll explain myself. There are documents in this file, my lord, that we had never seen and we'd requested, that were handed to your lordship, and we grabbed it like manna from heaven because we've never seen these documents. These documents gave a different view to what we had formed, and I accept responsibility when we read the correspondence with the state. But more significantly, my lord, what is the evidential value of some of these documents that have never been referred to as yet? They have been handed to your lordship. Your lordship gave an assurance that your lordship would read the entire file, and I'll use the one example that was the subject of some of the cross-examination. Tab C is there's an unsigned but unstamped replaced affidavit by Advocate the Nation that was handed to your lordship, but nobody's referred to it as yet, my lord. What status does it enjoy? If we go one step further, my lord, the actual index has a column that refers to comments. And that too, my lord, gives us some type of narrative that I'm unaware, nobody's addressed it as yet. The point that I wish to make, my lord, and why I want to urge your lordship to reconsider this interlocutory decision and to allow cross-examination, my lord, is going back to the first point that I made. What if your lordship rules now that the court has jurisdiction because your lordship hasn't heard everything, and through the course of the trial, your lordship establishes that yes, on cross-examination of Captain Carlitz and General Gerber, this court should never have allowed this trial to continue. Then there's a problem, my lord, because if one looks at the Criminal Procedure Act, I'm going on memory, but I'll check my act, my lord. Section 110, 111, Section 110 says, if the court finds that it doesn't have jurisdiction, it must remand the matter to the court that does in fact have jurisdiction. That's the relief. So you can't, with respect, my lord, reconsider this at a later stage and come to that ruling. It goes one step further, my lord. In section 110, it says, if the accused don't raise jurisdiction as an issue, then they are taken to have accepted the court's jurisdiction. So it becomes a major problem, my lord, that ought to be resolved up front and finally, not with the hope that nothing else comes out later or that nothing else is raised later that leaves any doubt in the court's mind, because it's not a situation that the court can revisit later on. So in my respectful submission, my lord, and it's not intended as impertinence, this court ought to grab as much information as it can at this stage and be receptive to it with the view to coming to that decision, because it's not an interlocutory decision that one can decide later on, like a confession or admission or a document where the evidential value is an issue, or whether even its admissibility is an issue where the court can reconsider later on. This is a final decision that the records entity says is appealable. So it can bring an end to the proceedings, or it can remain a thorn in the side of the proceedings until they complete it, because you cannot later on
against the Q17, yes.
I beg your pardon?
As far as the Q17 is concerned, it will be appealable.
Yes, my lord. Yeah. Yes. I'm saying the jurisdiction issue, my lord, and I'm saying from a Q17's perspective, Mr. Rotz's perspective, one cannot leave it hanging in abeyance and hope that nothing further comes out that can disturb the finding of the court, well knowing, my lord, that we have expressed a desire to cross-examine in the interest of justice on the relevant issue, nothing else. Because as your lordship envisaged, later on, Captain Carlitz could be called to testify, or you can reserve your right, and when he does that, you put the version. And then my question, my lord, to my learned friends and to your lordship is, what if then your lordship finds that there is something that's troubling me here in relation to the jurisdiction issue of Mr. Lotto? Should it not be ventilated finally here up front at this stage, rather than leaving it over till later? And it's not restricted to me, my lord. As far as I'm concerned, my submission remains. Anybody who can contribute to the determination of that issue has an obligation as an officer of the court to do so here and now, not later. So if in other words, to use the illustration that I've used previously, my lord, if I've been sitting with a transcript that went totally against the state's case and didn't raise it at that issue, but later on kept it back because I wanted to cross-examine Captain Carlitz during the trial and show that he's not telling the truth, and I said, look, but you've got a recording, then there'd be a problem, my lord. That's why I honestly and sincerely, as an officer of the court, believe that it's in the interest of justice that the cross-examination be allowed. It can only assist. It can't do any harm to this Honourable Court in the determination of this issue. Thank you, Mark.
Just one last thing, Mr. Addison. I've been listening to you. You've referred to a number of documents, and you've read parts from those documents. I'm only asking, as a last resort, isn't there a possibility that at least you can argue fully on what you have without doing any further cross-examination?
I don't believe so. The argument is possible, but it won't be as effective, and I don't believe that the questions will be answered. Let me use a practical example, if I may, Mark, and to get the precise issue for your Lordship, so that I can make it very clear. And this will be, I believe, I thought that I had convinced your Lordship, but I see that I haven't, but let me be very, very clear. Your Lordship knows, and let's use the document here. If one has regard to the warning statement, my Lord, and I've said to your Lordship, in the warning statement, and you've heard the testimony of the captain who's present and listening, and I have no issue with it. In the warning statement, which is under tab HR, my Lord. These are documents that are here, my Lord, and I believe that this is a perfect example. Lordship will see from that on the third page, at 11:26, Special Agent Bean of the FBI was excused. If one then turns to the request for legal practitioner, that's labeled page 2, paragraph 3. There's a request for a legal practitioner, and then you'll see that there's an undertaking on page 3, paragraph 5, that to would personally see to the drawing up of the statement would furnish me with a statement on or before 23 October 2021. And thereafter, it says the suspect was not willing to answer any questions at this stage and will provide a statement as agreed on or before 23 October 2021. And then your Lordship will see at page 5, paragraph 10, the interview was interrupted from 11:15 to 11:25. And the reason was to inquire about legal representation from Colonel Maka, I think it's Makalani, I could be wrong on the name. So you'll see that 11:25 they come back and say there's no lawyer available. 11:26 the FBI excuses herself. And they then end the interview with an undertaking to provide a statement by 23 October. But then, my Lord, if one turns back in this bundle to the very first tab, and to explain it, there's the request, my Lord, by the government of the Republic of South Africa to the government of America. And my Lord, in that request, one turns to page 9 of 15, and next to the letter F, there's something remarkable, my Lord. The Lordship will say, it says, warrant of arrest in respect of Mr. Pete Pompies. I don't know who Pete Pompies is or could be, but this is the heading that was submitted to the Americans, my Lord. Then it continues. The original warrant of arrest in respect of Ms. Charlotte was issued by the magistrate for the district of Bloemfontein on 7 October 2021, of which a copy is attached to Captain Carter's affidavit as Annexure B2. So what do we get from that, my Lord? And this is something that needs to be clarified in cross-examination. We get what purported to be, and is made out by the state to be, a sincere attempt to interview a witness to get a statement that went haywire, we say, because she failed to incriminate her former boss, the co-accused here, and which ended with her being given an opportunity to file a warning statement by the 23rd of October 2021. But how sincere could that have been if on 7 October 2002, this very same witness applied for and obtained a warrant for her arrest, irrespective of whatever version she was going to come up with. And we believe, my Lord, with respect, and I cannot urge your Lordship more, and I cannot emphasize enough how important it is that this ought to be resolved in cross-examination, my Lord, because these questions are going to linger throughout the trial if they're not resolved as soon as possible. That's just one example, my Lord, but it's a very clear example of where we hope to go in the cross-examination, my Lord, and I do believe that this demands answers. Now just engage with my junior, my Lord. My Lord, my junior misgovernor says, I ought to say, if you've seen, we've illustrated our bona fides as officers of the court, so we should be considered friends of the court. Is there a possibility of our clients and the co-accused benefiting? Certainly there is, but we make full disclosure. We're transparent about that, my Lord. We don't see it, but then one must ask, my Lord, in the balancing of balance of convenience here, is there any harm? We say not, my Lord. We will finish today. General Gerber is only available from Monday, my Lord. We can cross-examine, put it out there. We will definitely finish today. All the relevant issues. We're not going into issues beyond. We're not grabbing the opportunity of getting stuck into Captain Collins on unrelated issues or anything else. It's directly in point, my Lord, on objective facts and documents that we have here. And my Lord, there are more documents that would come into the cross-examination, but the documents that are before this Honourable Court in the application by accused number 13, Mr. Makashula, in his interlocutory, the annexures to his, and the correspondence attached to his affidavit that was sent to or copied or made available to Captain Collins through the process. Thank you.
Thank you. Gentlemen, the court will now stand down for a while until 11 o'clock, and then we will resume again. only, who pleaded a special plea to the charges against her to the effect that this court does not have the jurisdiction to try her case because her extradition from the USA was tainted by unlawfulness and irregularity. The state witness, now in the witness stand, has already been cross-examined by the advocate appearing for her. Mr. Ouders says that it is in the interest of justice that he also be allowed to cross-examine the witness. He said this in response to the court's question on how his client can have an interest in this court's verdict in the trial within a trial. Earlier in the trial within a trial, the court has allowed a transcript of an interview between two SA police officers and accused 17 in the USA to be handed in as an exhibit. The court did so in order to have all available information before it, in order to come to an informed conclusion in the trial within a trial. If the court now adopts the same approach, the court will allow Mr. Ouders to cross-examine the present witness, but under the strict condition that all questions must be relevant to the question whether this court has jurisdiction to hear and to try the charges against accused number 17. The court will not allow any questions to the present witness which will have a bearing on the merits of the case against accused number 13. The court does not know at this point exactly in which respect Mr. Ouders says that it is in the interest of justice that he cross-examines this witness, but I will take his word for granted as an officer of this court, and I will allow him to cross-examine as I've already indicated, but then on condition that everything he asks this witness must be relevant to the question whether this court has jurisdiction to try accused number 17. Thank you, Mr. Ouders.
Thank you very much.
Captain, you're still under oath to speak the truth.
Yes, I am.
May we speak it?
Morning, Captain. We've heard from your examination chief that you have more than 30 years experience in the South African Police Service. You confirm that? During September 2021, well, the starting point, I believe, would be on the 13th of November 2020, you were present in court when it was placed on record that accused number 13 was a state witness. Is that correct?
If I recall the date, yes, sir.
My Lord, if I may just assist my colleague, it was to be accused number 7 was to be a state witness, not accused number 13. This accused number 13 was the accused.
Thank you. Number 13 was arrested, Mr. Makashula, and it was placed on record that one of his bail conditions was that he may not communicate with the state witness, Ms. Chiloto. You agree?
I agree.
You were present in court and heard that. You agree?
Yes, I do.
At that stage, you had not obtained a statement from her in the docket, other than her statement before the Zondo Commission. Do you agree with me?
I do agree.
Thereafter, there was an exchange of emails where, and I don't want to repeat what other people have repeated, she had requested details of how she became a state witness, and it was responded that she could give vital information. Do you agree with me?
I do.
In response to that, she asked for a copy of the documents on which she was going to be made a state witness. Do you agree with me?
Yes, according to the emails, I do.
In fact, let's be specific. Um, Just waiting for the document. It's been referred to as AA1, where on the 18th of November 2020, Mr. Lotto sent an email to Advocate the Nation copying you, in which he said, "Good day, sir. I hereby acknowledge your correspondence with appreciation. I thank you for the clarification in this regard. It is loud and clear that I do not have any choice. I can assure you my 100% cooperation in this matter, solely because I respect the law. I will definitely appreciate a copy of the affidavit when you are ready. Going forward, I will hear from you best regards," and it's signed off by Mr. Lotto. Do you confirm that email? Would you like to see it?
I confirm.
All right. So it was, no, hang on to your lordship. So it was clear that she had responded saying that she had no choice in the matter. Do you agree with me?
That is what the mail says. Yes.
At that stage, you and Advocate the Nation knew that she had been represented by Mr. Nkwashu. Do you confirm?
No, I would confirm, yes.
That you'd been to the Zondo Commission with Mr. Nkwashu. It was on public TV and everything. Do you agree?
I haven't looked at everything, but I'll take your word for that.
So here she asked for a copy of the affidavit when the state is ready. Do you confirm that?
Yes, I do.
You've testified that no such copy was ever provided to her. Do you agree?
I do.
Now, from the 18th of November 2020, the next step, as we understand it, is the interview that took place on the 22nd of September 2021. Do you agree?
I do.
In that intervening period, from November 2020 to September 2021, did you or anybody from your office or from the prosecution provide her with a copy of any of the documents that were referred to in the emails?
To her, if I may ask.
Yeah. Yes.
Not that I'm aware of.
Well, speaking for yourself, you didn't.
No, I didn't.
Now, in order to go to America to interview her, there's a process that you have to follow in South Africa to make application to travel and to secure the funds and permission to do so. Do you agree?
Yes, I do.
When you did that application, what did you put as your motivation for the proposed trip to America?
Me, myself, didn't do the motivation. That was done by the NPA's office. And then corresponded with our head office. So from my side, I basically just got the instruction. Everything has been arranged, and I need to go.
When you got the instruction, everything has been arranged, you mean the travel arrangements and flight permission, etc. Do you agree with me?
That's good.
You never contacted Mr. Lott and said, "You're coming through on the 22nd of November. Can you tell us what time will suit you and can we get together?" You agree with me?
I do agree.
Instead, you remained silent and arrived there without any prior notification to her. Do you agree with me?
From my side, yes.
Why did you do that?
I can't say there's a specific reason, but all the correspondence directly with her was done by my senior official, General Gerber, and Advocate the Nation. Me myself wasn't, like I put it, it wasn't allocated to me to correspond, if I can put it bluntly like that.
In your evidence in chief, you said during September 2021 you embarked on a trip to the USA after Advocate the Nation and you had discussed and decided to have an interview with Mr. Lotter to get clarity on certain issues. Do you remember that?
Yes, I do.
So you weren't as uninvolved as you want to create the impression of right now. You knew why you were going, and it was after this discussion with Advocate the Nation to get clarity from Ms. Charlotte. Do you agree with me?
I wouldn't say that if you talk about the uninvolvement, obviously there's discussions between me and my prosecutor that I do agree with. That's part of the investigation. But the physical arrangements, I was not part of.
And you further testified in chief that prior to going to the USA, there was evidence that implicated Ms. Charlotte. Do you remember that?
I do.
So you knew at that stage that you had evidence that implicated her, and that's borne out by the warning that General Gerber gave her at the commencement of the meeting. Do you agree with me?
I do.
So at that stage, it's logical that you could either have been a suspect or a Section 204 witness or a straightforward state witness, but you can exclude the third because there's evidence that you said implicated her. Do you agree with me?
No, I do not agree with that.
Well, let me ask you differently then. If you're in possession of information or evidence that implicated her, I put to you that the only way that you could make her a state witness would be in terms of Section 204 of the Criminal Procedure Act. Do you have any comments?
No, that will be correct.
So you had this evidence that implicated her that you could use as a means to threaten her into doing things and giving a version. Do you agree with me?
No, I do not.
Well, what was the purpose then?
To get clarity on aspects. As I said, the information we had was there that implicated itself as we saw it. But by getting an explanation from it, that could exonerate it. That was the purpose, to get explanations on what we have on hand.
The only way that she could exonerate herself would be if she implicated accused number 13 and said that she had done so on his instructions. Do you agree with me?
Well, if you put it to say we went specifically after accused 13, I can't say that is the truth. We wanted clarity on the wording in the emails.
And what you said in your sorry, I didn't mean to cut.
No.
What you said in your evidence in chief is that you had communications between Ms. Charlotte and contractors requesting money for students made by her on instructions of the Premier as indicated in her emails. Is that correct?
That's correct.
So now it's clear we've reached the stage where you required her to implicate the Premier. Do you agree with me?
If you put it like that, yes.
I do. I put it exactly like that.
Then it is like that.
So we've now established that she was implicated herself, that she had the potential to become a Section 204 witness if she implicated Mr. Magashule. Do you agree?
Well, if she implicated Mr. Magashule, I don't think that will be a 204. That will be explanation on the questions that we asked.
Because then she'd be exonerated.
Well, then she would give a reasonable explanation, yes.
And she'd be exonerated. She'd say, I did this on instructions of my boss at the time.
Yes, basically, yes.
So that was the purpose of those interviews. And I can show it to you in your own email, in your own affidavit. You make it clear that that was the purpose. Do you agree with me?
Yeah, we wanted clarity, yes.
Right. And the clarity was the implication of her boss, the Premier. Do you agree?
Yes.
When that didn't work, the negotiations or interviews came to an end. They ceased. Do you agree with me?
Yeah, it became to a standstill, yes.
Now, we need to contextualize this out of fairness to both sides. And it works as follows. You knew Mr. Nkwashu acted for Mr. Magashule and Ms. Charlotte. Do you agree with me?
Yes.
You then, through the offices or through the emails, let's be more specific, of Advocate the Nation and General Carlett, made it clear that she may not communicate with Mr. Nkwashu. Do you agree with me, the attorney? It's there, I can show it you.
No, I agree. You just said, are we talking about myself or General Gerber?
The emails make it clear. I'm not attributing it to you. I said the emails from Gerber and the Nation make it clear that she may not communicate with her erstwhile attorney, Mr. Nkwashu.
Yes, I agree.
So in effect, you, prior to the 22nd of September 2021, told her she may not communicate with her attorney, and then set up a meeting with her without any arrangements by you, and never said to her, well, have a new attorney if you want in the meeting. Do you agree with me?
Well, not on my side.
You agree? That's
Yes.
what it is. Okay. So then you have a meeting, and you've told this court that in that meeting you had invited her to obtain legal representation. Do you remember that?
Yeah, that was the end of the first day, yes.
That doesn't appear anywhere from the transcript. Do you agree with me?
That is also, yes, I saw that.
Now, the creation of that transcript can be attributed to a number of people. It could be attributed to yourself and General Gerber, or Ms. Chilotta, or the FBI. Do you agree?
Well, it could be anyone, yes.
Now, you've told this court that you and the General, two experienced high-ranked officers, went into that meeting on 22nd of September with the view to recording the conversation. Do you agree with me?
I do.
As I understand what was placed on record by Advocate the Nation, that's not your recording, and your testimony was that the recorder didn't work. Is that correct?
That is correct.
So the logical conclusion is that here we have two highly respected police officers going to a meeting in America, intending to record it, and out comes the student who has no training or anything with the recording. Is the only inference if yours wasn't the one that we have. Do you agree with me?
Can you just repeat?
Yes.
I didn't understand, please.
The two of you, you and the General at that time, Brigadier, intended to record the
We
meeting.
did, yes.
You put a recorder, or he, I beg your pardon, put a recorder to see him on the table and said, I'm recording this conversation, and he gave a reason for it. He says there, I'm going to read it to you.
I'm
He
aware
says there are
that-
no misperceptions of what we are saying and what we are doing.
Yes.
That recording, as you say, never worked.
No, we did not.
The logical conclusion would be that if that didn't work, and this isn't what was recorded on that machine, this could have been recorded by Ms. Chilotta on her cell phone or something.
That is the assumption we're making, yes.
You then went one step further and said, well, there are things missing, there are omissions here. She could have cut certain portions. So is it your evidence that you're in this meeting, she had a cell phone, and she could control that which she recorded or didn't record in that meeting?
Well, most probably. I do not say everything. As I mentioned in my testimony, what looked for me suspicious, or not suspicious, is the fact that when we had a break, as it indicated in the transcripts, where she went and saw her boyfriend. There's nothing like that. And even, no, it's mentioned there, but it shows it was switched off because there's no discussion. It's not an ongoing discussion where she was. As well as the fact that the advice we gave her, as yourself mentioned, is not on the transcripts. And I wouldn't have made something known to that I've gave her advice, and then it's not on the transcripts. I don't understand why it's not there.
So you draw the inference from that she was the person responsible for this recording.
Currently, it's my thought, yes.
Because you see in the transcript where it says that there's a voice of another man, she steps outside of some sort, and then it continues, but that's not recorded.
No, that's correct.
So the answer is yes. Despite these two highly ranked police officers who intended to record, in your view, the person who recorded and is responsible for this transcript is Ms. Chilotta, the student.
Currently at this stage, yes.
Now, in that meeting, did you not notice that she was in possession of and utilizing the cell phone to do so?
To be honest, I cannot recall.
I'll take it off. Now I want to go to that meeting. Everything seemed very cordial in your exchange. Do you agree with me? There isn't an instance, and I've given you an opportunity to read this, where you can highlight one question that you asked that you absolutely refused to answer. Do you agree with me? on that day, the 22nd.
Well, yes, if you put it to say she didn't answer anything, she did answer everything.
And it ended off cordially with an arrangement to meet the next day in Washington, D.C., with a view to going to the embassy. Do you agree?
At the morning of the second day.
You had arranged to meet at a
At
station
Washington, yes.
in Washington. There's no mention there of having to arrange with an attorney to be present. Do you agree with me? Or a legal representative of any state?
When we picked her up,
No, when you ended off the first day.
no, we only gave her advice to maybe speak to a legal representative the evening.
But I understood your earlier testimony. So you're saying the advice or suggestion to employ a legal representative was only done after this meeting on the evening before the 23rd.
The first day's meeting, yes.
So you'll agree that it's logical then that
Sorry,
there's
Mr. Rhodes, I couldn't hear what you were saying.
Excuse me, my lord.
You said, was it at the end of the first
Of the
days?
first day.
You referred to legal representation for her.
My lord, we advised her that she should get in contact with a legal representative.
Yes, but I mean, the point is that was at the end of the first day, after the first day's interview.
That's correct.
Thank you. Thank you, Mr. Evans.
And the boyfriend stepping out, just for record purposes, at page 35, at the foot of the page. What you said, before we continue the questions, I want to find out, we've got a gentleman outside. Okay, sorry for that, let us continue. So that's where the boyfriend arrived, it would seem, is that correct?
Yes, it seems so.
And there's no recording that followed her of her meeting with the boyfriend, from which you infer that she must have switched off the machine for that, or the phone, or whatever it might have been, for the meeting with her boyfriend, is that correct?
That is correct.
Right. When she then returned, the questioning became some more relevant, and I'm going to take you, if I may, to the transcript. At page 64, where you say to her, you asked her about various people. Oh, sorry, I thought you had it.
Sorry, I thought that would file. I do have this. Sorry, actually. I apologize.
It's exhibit 11.
Page?
Page 64. You're on the issue of emails and just giving you all the different people that the emails would go to. If you want to just contextualize it from 62 onwards, you'll see it's the issue of emails. And at 64, the foot of the page, you say, are you aware of, okay, you are aware of the emails that you sent on behalf of the Premier? Good.
I see that, yes.
She asks you to who?
Okay.
65, you say for different companies, contractors, for donations. She says for the to business people, you say yeah. She then says for school funds, you say yeah, stuff like that. She says yes, I am aware. Then you ask her, you go off that topic and you say to her, now, were there any SARS certificates issued to those companies for tax purposes? How did you expect her to answer that question?
Well, I wouldn't know if she didn't answer. If she said she doesn't know, then I left it there.
Would you then say to, she says, you then say, I think it is a Section 18 certificate. I beg your pardon, Brigadier Gerber says, I think it's a Section 18 certificate. You say, yeah, I think it's a Section 18, and she says, I do not recall by whom, by the government or by who. Then you explain to her that for donations one would be entitled to a tax, it would have tax implications. Do you agree with me?
I do.
If you turn the page, you say to her, no, can I just re-explain to you if I may? She says, You say to her, you sent these emails on instruction of Mr. Makashula. She corrects you, she says, the office of the Premier. You accept that, you say, office of the Premier, she says, yes. So at that stage, the debate was what you referred to in your evidence in chief. where you were trying to pinpoint it to Mr. Magashule, and she was saying to you it wasn't him, it was the office of the Premier. Do you agree with me?
Yes, she was keep on saying office of the Premier. Yes.
And then you said to her, but obviously if you say the office of the Premier, you have to be specific now. And Brigadier Gerber says there should be a person. You say, yeah. Then Brigadier Gerber says the office cannot, and she says the office of the Premier would be us. When you're assisting people who come to the office of the Premier, to me it is the office of the Premier who is assisting them, right? Then you say, okay, but you must remember we cannot talk to as an organization. The Premier's office is, we have to put it to a person, you understand? She says, okay. Then you say to her, so when you send these emails, these mails saying in the mails on request of the Premier, you're requesting a donation, say, for studies for this and this person. She says, okay, then, and there's intervening and indistinction, and then she says, then you continue. Do you mean the Premier told you to write an email to businesses saying, listen, I'm asking for donations for this and this and this student at this and this university? And she says, okay, that is not how I did it. So she's telling you what you did in fact do. Do you agree?
Well, she just said this is not how she did it. She didn't go and explain further, if I'm correct.
And then she says in line 10, what I did was request from the office of the Premier, because the people who would ask help would come to the office of the Premier. So me handing it, I was handing it as the office of the Premier. I was not saying specifically the Premier said you must help this person, because even when I ask, it was a request, not a directive, that you must help these people. Do you agree?
This is what it says, no?
So she's telling you, you can't attribute it to Mr. Magashule, you can attribute it to the office of the Premier. Do you agree? That was her version too. It's black on white.
Yes, no, I agree.
And she goes further and she explains, I would ask if is it possible that you can assist us with this kind of students, so forth. You say, so you're basically telling me you asked own initiative, you used own initiative to see who is in need and then request assistance. She says, all of them, not my own initiative. We would have different students who are coming to the office, we would draft. Now, what he is trying to say is, remember earlier on we asked you, did you take executive decisions? And you said no. She says, Then Gerber says, now someone coming to the office and requesting a bursary or whatever, she says, You say, no, it is an executive decision for you to approach a company to say, please, to donate, even if it is on the office of the Premier. She says, You say, money for a student. She says, Then you say, did you? Or are you saying that you took those decisions by yourself to approach those companies and ask them for money? And she says, because Then you say to her, not informing the Premier. And she says, no, the Premier would know, and Miss Janet Kay would know, but it was the procedure of financial assistance that has been going on in the office of the Premier. The Premier would not, the Premier, even if he speaks, he would say, no, if the bursaries are finished, we must do something to help the students. You understand, it was not to be a directive to say, go and ask this person about this. It was the nature of the indistinct, knowing that even if the government cannot help to this extent, then we would go out and request financial assistance for these students. Brigadier Gerber says, on whose instruction? And she says, from the office of the Premier, am I not understanding your question? And now we start the debate all over again. But what I want to put to you, and I'm not going into the merits, it's only on this issue. You and Brigadier Gerber were looking for the answer on the instructions of Mr. Magashule. Do you agree with me?
That is what the emails implicated, and that is what we wanted. Yes.
Thank you. Right. That's how you read the emails, and that's what you wanted. Do you agree?
Yes.
Right. Because it continues. Brigadier Gerber says, the office cannot give you an instruction. You say there is too many people working at the office of the Premier. She says, correct. You say, okay, but who gave this instruction? Not the office of the Premier. There is 20, 50 people working. Gerber adds, there is Janet Kay, there is whoever is in the office. We are asking who gave the instruction. A simple question. She says, I'm saying yes, and I'm trying to explain it that it has there's been an ongoing thing in the office that whenever we do not have funds, we go and outsource for them. And it continues. Brigadier Gerber says, now I understand, but you say we. Who is the we? And you said specifically earlier you do not have executive powers. She says yes. Captain Carlitz then says, so me in my office, let us take my office for instance, you will not go and approach someone to do something on behalf of the office. It is not okayed by me. She says, of course. You say, now in your office, in the Premier's office, she says, the Premier would know that we are outsourcing for students. And you say, okay. She says, yes. You say, so he would be aware of, and she says, he would be aware. You say, okay, and same with the And then you say, would he indicate to you who to approach? So maybe look at this businessman or look at that one, or, and she says, I doubt, because I would be the one sending requests to different business people. And you'd say, and how would you know now? And she says, and then remember, the last time I was explained, they also got a list from the database. Also got a list from the laptop, the very same laptop that Miss Maria was using. That is why I'm saying it is an ongoing thing that I found there happening. Also, my own, I would just find out of the simple thing that I used was indistinct foundation. If I hear that there is an indistinct foundation who is assisting the students, I'll also find their contact number and ask. We also have students who are asking for this. Would you be able to help? So I did not have any specific people that I had to contact if I'm making it clear. Then you say, yeah, no. She says there was, and you say, yeah, no, I understand. So in general, the process that is followed at the office of the Premier Employees, she says, all right, you say, is to ask for assistance from business people. She says, correct. And then you ask her, but the general instruction to do this was given by the Premier. She says, I do not know if it is. You intervene, but when you came there, that was the norm. She says, yes, it was. And obviously, you say, and she says, at the office of the Premier is always. And you say, obviously, someone told you this is the way we do it, because otherwise, you took that decision on your own. She says, not the decision that I took on my own. So what I want to put to you is you are saying to her, either you take responsibility for the decision, or you allocate it to Mr. Makashuli. Do you agree with me?
Yes, I do.
And she was saying to you, no, I can't attribute it directly to him. There's several people working in that office that she refused to be pinned down on the Premier or Mr. Makashule personally. Do you agree?
Do you mean by possibly implicating someone else rather than the Premier?
That she refused to implicate the Premier or Mr. Makashule to identify him. Do you agree with me?
Yes.
And that's what led you that night, or after that meeting, to engage with Advocate Donation and say, listen, this woman's not cooperating. We need to possibly warn her, make her a suspect, or make her a tour for whatever you discussed with him. Do you agree with me?
That was part of the discussion, yes.
Now we know there's the second meeting took place, 23rd of September at the embassy. There were no recording machines allowed by anybody. Do you agree with me? So there's no recording of that meeting. So what we know is that at some stage, and you know the time, you completed a warning statement for her. Is that correct?
That's correct.
So you had a copy of a warning statement, but you didn't ever provide a copy of her own statement or the requested documents to her. Do you agree with me?
The statement from the Commission.
Yes.
Yes.
Any reason why that's the case? That this woman's asked you, please bring the documents, please send the documents. You can get from the transcript, she hadn't bathed, she hadn't gotten ready.
As I explained on my testimony during the week, it would happen, not to say in this instance, in general, that if a person provides an affidavit or an explanation, it's not to say that we will provide that affidavit during questioning to confirm whether the facts given during the first or another interview corresponds with what we are asking.
Now, can you just give us the times that events took place on the 22nd of September? I'm talking about the first day. At what time did you meet with the FBI with the purpose of going to her home address?
Yeah, if I recall correctly, it was around about 7:30, 8 o'clock.
And then what time did you get to her house?
Just past 8, 8:15, somewhere there.
And then how long did it take them to bring her out of there to attend the interview?
15, 20 minutes maybe.
So we can infer from that she was cooperative. Here's a woman, she wakes up, there's the FBI at the door, no prior notification, she's dressed and out within 15 minutes.
Well, I don't know whether she was dressed. I didn't see her before.
When you say you don't know when she was dressed, you mean when she came out the door, when she was in the house?
No, the FBI approached the house. I only saw her when she came out.
She came out dressed?
Yes.
So you knew she was dressed?
Yeah, but I don't know beforehand.
No, but she says it on the recording.
I
I haven't
understand.
had a chance to bath or anything.
Yes.
In
I
15 minutes, you don't expect that she got them to wait while she bathed or anything like that. She came out and cooperated.
I agree.
Did you ever say to her, sorry for not telling you that we're coming or making an arrangement with you? Can you now set your day aside or anything like that?
Not myself at the residence. It could be that it was discussed when we arrived at the hotel.
So I want to put to you, and I'm going to give you every chance to qualify this. That was a compulsory interrogation, do you agree with me?
For that specific days.
Yes.
No, we set out 3 days for the interview.
She was compelled to attend, do you agree with me?
Well, yes, in a sense, but if she have said sorry doesn't suit her, we would have accommodated like we did.
Captain, you arrived there 20 seconds and we're having an interview today. So the FBI went in and ensured that she came out escorted by the FBI with a view, even driving her own car, to attending a compulsory interrogation. Do you agree with me?
I do, but as I said, I do not know what was the discussion between the FBI and herself. I do not know what they told her. I do not know if they forced her. I do not know. The thing is, when she came out, it was for me voluntarily.
Let's ask the question in the reverse order, okay? Is there any reason why you never made any arrangements with a former attorney to interview her? Did you find Mr. Nkwashi and say, listen, we're deciding to make this lady a state witness. We're going to be seeing her. Please don't have any communications with her.
Not from my side now.
Is there any reason why you never contacted her and said, listen, I'm coming through on the I'm thinking of traveling on the following days. Please tell me what suits you and we can arrange to meet.
Not from my side. No.
But why not?
As I explained, I did not do the communication with her.
Yeah, but nobody did. So it's not like you're saying somebody else could have done it or should have done it. I'm not finished. You planned a trip overseas. You got budgetary allowance. You went all the way to America. Everything was sorted out. But not once did you bother to say, well, let's make sure she's there. What if she goes on holiday? Or what if she's not available? What if she's having an operation? What if she's in class? I mean, it's just normal human behavior to find out if a person's available.
I agree with that.
So why didn't you yourself ensure that she's available, or ensure through other people, the FBI, anybody else, to make an arrangement? Please, Mr. Lotta, be available for a meeting.
All I can say is the communication was said to be done by General Gerber and the African American.
I don't use his term of throwing them under the bus. I'm not going there. Okay.
No, I'm not. That is how it is. That is how it is. Although I was CC'd into the emails, that was the decision that was made. And if it comes to me now to say, why didn't I do it? It was a decision that the communication will be done by them.
I find it totally unacceptable, and I'm going to put it, if I'm going to dinner tonight, I'll even ask my junior, the attorney, the restaurant, I'll make an arrangement. I don't just arrive, because anything can happen. The restaurant can be closed, they can be unavailable. You were unaware of any arrangements that have been made with her. Do you agree with me?
Yes.
It's logical, there was no arrangement made with her.
Yes.
Yet you never asked them, have you guys sorted this out? Is she expecting us? Where are we meeting her? Or anything to that effect? You just ride along as a passive observer to see what's going to happen. Is that your evidence?
I cannot answer that in any sense. There's so many discussions that took place. As you say, the normal person. Most probably I did ask that the arrangements were made. Most probably. I do not say it happened. Most probably.
Yeah.
Okay, there's no evidence to say it. But in the other instance as well as, I do not know what the FBI did on their side before we arrived. Did they make sure she's at home? That I do not know as well.
No, I'm going to put to you as a fact. Your intention was to catch her by surprise and intimidate her. It's so obvious, it stands out. There's no other logical explanation, sir.
If I can answer like that, yes, it is your opinion.
No, it is. I'm putting it to you as my opinion, but I'm saying to you, my opinion also is that there's no other logical explanation for this type of conduct.
No. I do not.
You don't accept it?
No, I do not.
Now let's go one step further. You were here when I addressed the court, okay? On the 23rd, when you had your meeting, you left on the basis that you would have 1 month within which to provide you with a warning statement, having consulted with a legal representative. Do you agree with me?
I do.
You've heard and you're in court that prior to the expiration of that date, you applied for and secured a warrant for arrest.
I must look at the dates.
I'll give you the dates,
Yes.
so you can be rest assured.
Yes.
You're attached to your affidavit, and you'll find it in the Exhibit 11 under the A tab.
Sorry, mine isn't referenced like that. May I ask?
Oh, sorry. Thank you, sorry. Being handed to you. If you'll turn in tab A to page 9 of 15, and just familiarize yourself with the document. It's your affidavit in support. I think it's your affidavit.
No, it's not.
It's not your, it's an affidavit by Navilla Somaru, the Director of Public Prosecution, in support of the request for extradition. And if you turn then to page 9 of 15, you see a heading. See the heading there? Warrant of arrest in respect of Mr. Pete Pompey.
Yeah, I see that.
Where's Pete Pompey?
I don't know if it's a typing mistake. I do not believe
There's no Pete Pompey involved in this matter.
No, there is not.
And this was the official request to the Americans. It says the original warrant of arrest in respect of Mr. Choloto is issued by the magistrate for the District of Bloemfontein on 7 October 2021, of which a copy is attached to Captain Collis's affidavit as Annexure B2. You see that?
Yes, I do.
Now you had a meeting with her. Now I can show you the warning statement. 23 September 2021. You and General Gerber gave until the 23rd of October 2021 to provide a written warning statement, having consulted with her legal representative. You agree?
I do. Can I just rectify one thing? Yes. That date is determined by us. We ask the person with whom the interview is held what date will suit that person.
Yes.
No, I just want to clarify.
I'm indebted to you. Thank you. It's very, very kind of you, because we'll see how significant it was. So you asked her, by when will you be in a position to consult an attorney in America or legal representative and provide us with a warning statement? And she chose 23 October 2021. Do you agree?
Yes.
And you agreed to that, is that correct?
Yes.
You said, no, that's fine, that's reasonable, 1 month. And you recorded it as an undertaking in the warning statement that she had then undertaken to provide a warning statement in writing by 23 October 2021. You agree with me?
I do.
Right. On what basis then, prior to that date, did you go and apply for a warrant for arrest?
The warrant was asked for afterwards.
No.
The due date is 23 September. We asked 7
Now,
October.
you're in the meeting 23 September.
No, no. No, can I just have a
Okay,
look at the
Captain, yeah,
No, can I just have a look
please,
at
I don't want to
No.
try to catch you up.
No, no,
Look
I
at the warrant, look at
the No, I just want to rectify.
look at your warning statement.
Please, if I may.
Please.
Sorry, I hear what you say. Yeah, I see the due date for the affidavit is the 23rd of October.
Yes.
And we did the warrant on the 7th. Yes. I apologize, yes, you are correct.
That will be stated now. On what basis did you do that?
Well, that would have been on instruction,
Again, from the advocate and the general.
not the general, my prosecutor.
The advocate donation.
Yes.
Okay, so now let's just put this into bona fides of doing everything correctly, okay? You sat with the student on the 23rd of September. She said to you, I want a legal representative. It took 15 minutes to find one, it wasn't available. You then terminated the meeting on a clear and unequivocal understanding that she would have 1 month within which to provide a warning statement because of her right to a legal representative before she does so. You agree? Yet somehow, you come back to South Africa and you get an instruction and you apply for a warrant long before the expiration of that time period. Do you agree with me?
According to this, yes.
Well, we've got nothing else to go by.
No, I agree.
So let's just work it out, okay? You were there on the 23rd of September in the meeting. You give her 1 month, but within 2 weeks you apply for a warrant. You agree?
I do.
At the time that you applied for a warrant, she still had more than 2 weeks to provide you a warning statement. Do you agree with me?
I do.
Did you mention that at all to the magistrate to whom you applied for a warrant? Did you say, I was in America, I asked her for a warning statement, she insisted on an attorney, so I said to her, you've got till the 23rd of October, but here I am before you applying for a warrant.
I cannot recall whether I did.
I guarantee you didn't tell that.
I take your word for that.
No, because the magistrate would have said to you, if he or she applied their mind, if you've given the person till the 23rd, let's wait till then. It's logical, do you agree with me?
I do.
So why did you behave like this?
As you said, gone through anyone under the bus, but it was on instruction.
On whose instruction?
I think it is.
So what we must infer from this is that where you previously highlighted and told all the different courts, Free State and the Constitutional Court, that this woman undertook to provide a warning statement by the 23rd of October, it didn't have really any bearing on you because you were going ahead with a warrant anyway.
On instruction.
On instructions. Let me put it like this. You were instructed to go against the time period that you'd given her and you accepted that and proceeded. You agree?
Yes.
And this was a woman whom you thought could exculpate herself and become a state witness, not even a Section 204 witness on your testimony today. Do you agree with me?
Yes, I do.
Provided she did one thing, she implicated her boss, Mr. Makashula. Do you agree?
Put a name to the wording, yes.
So,
Put your name to?
Put a name to the wording of the emails.
Any name or specifically?
A name, just a name. If you had a name, we would have been satisfied.
no. You were given names. I can show you in the transcript. You wanted one particular name, Mr. Makashula.
Well, it says Premier, so logic says it would be the Premier.
Captain, I'm not going to let you out of this one. Your own affidavit in the Constitutional Court says that. I'll read it to you if you like.
No.
You wanted his name. His Lordship's asked you the question. You wanted the name, Mr. Makashula.
Yes, we did.
We'll get there, thank you. Now, I need to, unfortunately, go back and explain to you what had happened because it came out of the application. Only in relation to this, the Ms. Chilota, Mr. Makashula, and the police and prosecution. You remember there were newspaper articles that featured about this matter that revealed after the 13th of November that she would be a state witness. Do you agree?
I recall something like that, yes.
And we've seen the emails that then followed after those newspaper articles.
Yes, between the advocate and the general. Yes.
And Mr. Nkwashu at the time acting for both Mr. Makashula and Ms. Chilota. You agree with me?
I do.
And those had all been referred to prior to the meeting at the Sheraton Hotel on the 22nd of September 2021. Do you agree with me?
Yes, the correspondence, yes.
But in the end, they culminated in what the accused number 17 referred to as an open letter or statement on the 6th of November 2021. It's in the file, I'll show it to you. It's difficult to find because it doesn't have its own tab, but it's in one of the tabs.
Stories, let us take the lunch break
If
until
I
2
may, I
o'clock.
was going to propose that I will find the pages and the
Yes, court will resume again at 2 o'clock. Court adjourned.
Right.